Fissure maps, understanding the land beneath the property. As we continue building on disclosure, we now move deeper into environmental and property-specific risks, areas that often go unnoticed until they become major issues. One of the most unique risks in Arizona real estate is earth fissures, and fissure maps are a key tool in identifying these hazards. Fissure maps are developed and maintained by the Arizona Geological Survey and identify areas where earth fissures have occurred or are likely to occur. These fissures can impact structural stability, drainage, and long-term property value. Under AAC R4-281101, licensees must exercise reasonable care and disclose material facts. While agents are not expected to be geologists, they are expected to direct clients to available information and avoid misrepresentation. Example: a property is located in an area known for fissure activity, but the agent does not reference or provide access to fissure maps. After purchase, the buyer discovers structural issues linked to fissures. This may lead to claims that the agent failed to disclose or investigate material concerns. In 2026, best practice is not to interpret fissure maps, but to provide them as part of due diligence resources and encourage buyers to investigate further. Earth fissures in Arizona, a material condition. Earth fissures are cracks in the ground caused by land subsidence, often related to groundwater withdrawal. These fissures can damage foundations, roads, and utilities. In Arizona, fissures are considered a material fact when they impact or may impact a property. This ties directly to case law, such as Hill v. Jones, reinforcing the obligation to disclose material conditions that are not readily observable. Example: a seller is aware of a fissure running along the edge of the property, but assumes it is not significant. Failure to disclose this information could result in liability if the buyer later experiences damage or loss in value. The key takeaway is that environmental conditions, even if outside the home itself, can still be material and must be disclosed when known. Lead-based paint, federal disclosure requirements. Lead-based paint disclosure is governed by federal law under the Residential Lead-Based Paint Hazard Reduction Act of 1992. This applies to residential properties built prior to 1978. Sellers and agents must provide a lead-based paint disclosure form, deliver the EPA-approved pamphlet, allow buyers a 10-day inspection period, unless waived. Failure to comply with these requirements can result in significant federal penalties. Example: an agent forgets to provide the lead-based paint disclosure on a 1965 home. Even if no lead is present, failure to provide the disclosure is a violation. This is one of the most strictly enforced disclosure requirements and must be part of every applicable transaction. Pool barriers, safety and liability considerations. Arizona law requires that residential pools meet specific safety standards, including barrier requirements designed to prevent accidental drowning. These requirements are particularly important in family-oriented markets like Phoenix and surrounding areas. While pool barrier compliance is often verified during inspections, it is also a disclosure issue when known deficiencies exist. Example: a seller knows that their pool gate does not self-latch but does not disclose it. If an issue arises after closing, this could lead to liability for failure to disclose a known safety concern. Brokers should ensure that agents encourage inspections and properly document any known issues related to pool safety. Seller's Property Disclosure Statement, SPDS, the cornerstone of disclosure. The Seller's Property Disclosure Statement, SPDS, is one of the most important documents in Arizona real estate. It is the primary tool used by sellers to disclose known material facts about the property. The SPDS covers a wide range of topics, including property condition, repairs and improvements, environmental issues, legal matters affecting the property. While the seller completes the SPDS, agents have a duty under AAC R4-281101 to ensure that it is delivered and to avoid knowingly transmitting false or misleading information. Example: a seller leaves sections of the SPDS blank or provides vague answers. The agent should encourage complete and accurate disclosure rather than simply accepting incomplete information. In 2026, brokers should emphasize that the SPDS is not just a form, it is a risk management tool that protects both the seller and the brokerage. Superfund and Water Quality Assurance Revolving Fund, WQARF, Environmental Contamination Risks. Environmental contamination is another critical area of disclosure, particularly in Arizona, where industrial and mining activity has impacted certain areas. The Federal Superfund Program and Arizona's Water Quality Assurance Revolving Fund, WQARF, Identify and manage contaminated sites. Properties located near or within these areas may be subject to environmental risks that must be disclosed. Example: a property is located near a designated WQRF site, but the buyer is not informed. Later, concerns about groundwater contamination arise. This may lead to claims that the agent failed to disclose material environmental risks. Brokers should ensure that agents are aware of how to access information about Superfund and WQRF sites and incorporate this into the due diligence process. Section Review: Bringing environmental disclosure into focus. This section expands disclosure into environmental and property-specific risks, reinforcing that material facts are not limited to what is inside the home. We now see the full picture. Disclosure includes environmental conditions, safety issues, and regulatory requirements. Agents must direct clients to reliable information and encourage due diligence. Sellers must disclose known material facts through tools like the SPDS. Brokers must ensure consistency and compliance through supervision. Environmental disclosure is about awareness. The more informed the client, the lower the risk for everyone involved. As we move forward, the next section will focus on enforcement, violations, and how brokers can proactively identify and correct disclosure issues before they escalate into complaints or legal action. Online discussion. Why are environmental issues considered material facts in real estate transactions? Answer: because they can impact property value, safety, and a buyer's decision, making them essential to disclose under Arizona law and case law. What is the primary purpose of the SPDS? Answer: to provide a comprehensive disclosure of known material facts about the property from the seller to the buyer. Why must agents provide Fisher maps rather than interpret them? Answer: because agents are not experts in geology and should direct clients to reliable resources while avoiding misrepresentation.